Good afternoon. It's 3 p.m. on Monday, the 23rd of November 2020. I'm Barrister Daniel Barnett from Outer Temple Chambers, and I'm joined for a Q&A session this afternoon by the President of the Employment Tribunals in England and Wales, Judge Barry Clarke. Now, some of you may remember that Judge Clarke did a Q&A session about 6 months ago in May 2020, 3 weeks into his role as President of Employment Tribunals England and Wales, having just started a week or two after lockdown was announced, and he was faced with a largely non-functioning tribunal system and significant economic uncertainty. Today, he's going to be updating us on the position, telling us where we are now and what the future holds, and then answering any questions that you may have. This session is being recorded, so you'll be able to watch it back if you want, or if you have to leave partway through. Judge Clarke, before he became President of the Employment Tribunals, was a recorder of the County Court, a deputy chair of the Central Arbitration Committee. Before that, he was a fee-paid employment judge for 5 years, a salaried employment judge for 5 years, and a regional employment judge for 5 years. And before that, he was a partner in a national law firm. He was an ACAS arbitrator. He was trustee of a law centre, and between 2006 and 2008, he was the national chairman of ELA, the Employment Lawyers Association. He's also edited a book called Challenging Racism. I'm going to turn to Judge Clarke in just a moment. After that, it's your chance to ask questions. If you're watching this live as opposed to the recording, you can type your question into the Q&A box below. You can see, if you click on the Q&A box, the questions that other people have asked, and we're going to prioritize people whose questions are, unsurprisingly, the most popular. The way to make someone's question popular is to give it a thumbs up. So the more thumbs up a question gets, the more likely we are to select it for asking to Judge Clarke. Now, once your question is selected, we will unmute you. Everyone's muted at the moment. We will unmute you at our end. Please don't play with your mute button, because if we unmute you and you hit mute, you're muted again. Please make sure your camera is turned on if you want to ask a question. If you turn it on now, nobody can see you anyway. It'll only come on when you ask your question. And when we open your line, you don't need to say, "Can you hear me? Can you hear me?" Assume we can hear you unless I say otherwise. And on that note, I'm going to ask Judge Barry Clarke, President of the Employment Tribunals England and Wales, to tell us a little bit about what's been happening in the employment tribunal system. Judge Clarke.
Good. Thank you, Daniel. Can you hear me? So I just want to start really with some thanks. I think that's appropriate. I want to thank all of the employment judges and non-legal members of the employment tribunals in England and Wales. They've worked incredibly hard over the last few months to keep justice moving during the pandemic in the face of really quite extraordinarily challenging circumstances, and they have embraced new methods of working with a speed that is frankly astonishing. So thank you to them. I also want to thank HMCTS. So for those of you who don't know, that's Her Majesty's Courts and Tribunals Service. They are the civil servants who support the justice system. I've said on several occasions that they can only do the best that they can do with the resources that they have. And given the limitations that they face, they have done great work. I include in that thanks the clerks who are clerking the CVP hearings that some of you may have attended. And I include the senior civil servants who have done their best to deliver the requests I make for more IT hardware and software that supports the delivery of justice in a more remote setting. I think it's appropriate to thank ACAS. They've managed to keep their services going, their very important conciliation services going, by working remotely during the pandemic. But I also want to thank, and this is the last group I'll be thanking, is all of you, our users, who've shown incredible adaptability. Those listening to this conversation that Daniel and I are having this afternoon, lawyers, HR specialists, trade union officials, if I can direct some comments to you, because you're professionally invested in the employment tribunals system, and you understandably want to see us being resilient. And I want to say I've been also hugely impressed with how resilient you've been. I've seen solicitors and barristers, HR professionals, trade union officers, trade unions themselves putting out detailed and free material on the operation of the furlough scheme to demystify the complexities of employment law during a public health emergency. And that's a considerable public service. It's been a huge pro bono effort. And it really, I don't want to sound overly grandiose, but it supports the rule of law because it means that people are more likely to understand what the law requires them to do. And that is a hugely important matter. I've also seen pro bono efforts by university law clinics, the Employment Lawyers Association's own ELIPS scheme, move online in a very impressive way. Only a few days ago, I watched an excellent ELA webinar, which they have kindly made open access to the public on managing ET remote hearings. So thank you to all of you as well for helping us keep things going. And frankly, for your forbearance, given the delays that you've experienced in getting cases heard and in having responses to emails, correspondence, and the like. But we also mustn't lose sight of what has brought us to this place. I said earlier, a public health emergency, and that means that justified expressions of gratitude to those I've just mentioned must be tempered by solemn recognition of the havoc that COVID has wrought over the last 9 or 10 months or so. Lives lost to COVID, livelihoods lost to redundancy, household incomes that have shrunk as a result of jobs being lost, enterprising and successful businesses who've had to shut their doors, even with the support that they've been able to receive from the government. And all of these things, none of us could have predicted 9 or 10 months ago when the world seemed very different. And I know that you want us to be in a position to respond to that so that we can continue to deliver workplace justice throughout this huge disruption to the labour market. And that is a challenge. Candidly, our caseload, which was already high, has now risen to an all-time high. New cases are coming in at a vastly increased rate, and people rightly want to have their cases heard within a reasonable time. And of course, by people, I mean both workers and employers, for whom resolution of a dispute matters enormously. So, what are we doing to try and recover? Well, I'm just going to make a few points really to try to emphasize that we are making really, really strenuous efforts to improve the delivery of remote justice, to get business back as far as we can to usual, and to be able to tackle the challenges of an all-time high caseload. So the first thing, I guess, has to be this expression CVP, the cloud video platform that probably none of us had heard of 9 or 10 months ago and now trips off the tongue. CVP is, as you know, the main weapon in the HMCTS armory to deliver remote justice or video justice. A web browser enabled video hearing system. And compared to where we were on the 2nd of June, which I think was when Daniel and I last held one of these webinars, which was the day after Shona Simon and I had issued our roadmap to recovery. And at that point, we had just secured across England, Wales and Scotland 150 of these CVP rooms. And hopefully enough of you listening have tasted ET justice or civil justice through the use of a CVP room to know what I'm talking about when I describe it in those terms. But we needed more of them. We now have more of them. And we currently now use 327 CVP rooms across Britain in the employment tribunals. And for England and Wales alone, that's 279 of those rooms which belong to us. And that supports the delivery of justice through what we now term fully remote or wholly remote settings, where all participants are dialing into this virtual space to have their hearing. But we also need to scale up to deal with in-person hearings. That is trickier because of the ongoing need for social distancing within tribunal venues. And the reality is that we can't get in-person hearings back in the numbers that we need to tackle the caseload, because you just can't have that much footfall in an HMCTS venue without compromising public safety. So the next best approach is what we are calling a partly remote or a hybrid type of hearing. And judges have done incredibly well to try and mix and match whatever IT equipment they can get their hands on for hybrid hearings to work. But what we really need is the type of video installation that exists in a significant number of county court venues. And for those of you who know what I'm talking about, it's a large camera that can be focused on any different part of a hearing room, which enables remote participants to see what's going on in the tribunal venue or in the court venue itself. So you can have people legitimately accessing the hearing remotely, whilst also having people within the room appropriately distanced. And we are hoping to have that type of video equipment installed in all of our main venues and hearing rooms by the end of March 2021. And I hope to be able to push up the priority list for deployment of these devices, those ET regions that currently have none of them, and a significant number of our regions do have one or two, but we want to increase the number that hold this important piece of equipment, because that is the what we need to unplug the ability to increase the number of hybrid hearings that we can hold. So additional to that, I should also mention that HMCTS have assisted by delivering to judges and members the PDF reading software, which makes us better able to receive and handle electronic bundles. And here again, I guess, is an example of necessity as the mother of invention, because 10 months ago, I don't think I would have chosen to use an electronic bundle. Now, having used them, having bookmarked them and navigated them and found in them what I want to at the push of a few buttons, I have to say I'm a convert to them. And I'm slightly disappointed in myself that it took me so long to realize the value of electronic bundles. Of course, that means that for judges and members, that they need to have the software to access it. That's now been made available to the 1,400 judicial office holders that serve the employment tribunals in England and Wales. And in order to ensure that not just professional users, but litigants in person can have appropriate access to the documents they need for a hearing, we need to find a way to maintain the use of paper bundles as well. And so many of you will know that I issued a couple of months ago presidential guidance on the conduct of hearings, in person, hybrid and remote, which has sections on how you might continue to use paper bundles for those litigants in person, whether workers or employers, who understandably still don't have access to the software that's needed to navigate those bundles. But for those of you who are professional users, please do read that guidance carefully, because we are relying on you to get those bundles in good order to assist us in disposing of the case as quickly as and as fairly as we can. So that's a little bit there about the IT aspects of it, but I will just briefly mention that CVP is not the end state product. It is, in effect, if I can use a slightly corporate expression, the minimum viable product. And what is in development is a more advanced version of CVP, currently going by the phrase video hearing or fully affected video hearing, VH service, or the FVH, fully video hearing service. And any of you who've recently appeared in the Southwest England Employment Tribunal region may have been fortunate to witness this process, because that is where it is being piloted at the moment. And it's a more stable system, but we need to ensure not just that it is as good as CVP before we roll it out nationally, but that there is clear blue water between what the new system can deliver over and above CVP, so that having worked hard to move the judges and members and our users over to CVP, that they will willingly embrace the improved version of it that I hope is coming our way. Additionally, to assist us in our recovery, I have worked with Shona Simon and colleagues in Bays and the Ministry of Justice to produce amended rules of procedure which better support the conduct of remote hearings, but also allow us to bring in tribunal caseworkers, who are known as legal officers in the Employment Tribunals Act, because that will give us another source of increased firepower to get through the workload that we face. Because the problem of an inflated caseload is not simply having more cases in the system that require hearings, it's that those more cases in the system generate correspondence, things that need to be referred for decisions on case management matters. And if you don't have the administrative staff in place to receive and analyse and refer those requests, they don't get dealt with as speedily as they should. And so tribunal caseworkers who are going to be recruited within the next few months offer a new source of firepower for us to tackle that type of work. And that increases the prospect that a hearing will be effective, so that when the judge and the members look at the file, they don't see that there's an outstanding application for something that, if it had been dealt with sooner, would have meant that the hearing could stand. So we want to make sure that we have as many of those caseworkers on board as we can get funded, and hopefully they'll be in place and bedded in by the next financial year. I guess the proof is in the pudding to our recovery, and I can say to you that we are now, again, if I can resort slightly to management speak, we talk of disposals as well as receipts. Receipts are the cases we've got coming into the system, which are going up, and disposals are the cases we have going out of the system. And that's those cases that are resolved as the consequence of a hearing or in consequence of the parties settling. And our disposals, of course, collapsed in after the end of March through April and beyond, as a result of in-person hearings being abandoned for reasons that you all understand. Whereas now I can say that our disposal rate is back to where it was in March. And that's not credit to me, that is a credit to the judges and members of the system who have embraced CVP and got hearings back up and running in a remote setting in order to get that disposal rate back up. So that's one other reason why I have been so keen to thank them. And getting that disposal rate back up is also demonstrated by the fact we are now sitting the same number of days per month as we were back in January and February and early March. So member sittings are back in numbers, fee-paid employment judge sittings are back in numbers. But still, we need more. We need more resources to have more judges, more administrative staff, more premises, more IT, and all the rest of it. And all I can say in that regard really is that as the jurisdictional president and working with Shona Simon north of the border, we work alongside our colleagues in HMCTS to try and successfully get those extra resources that everyone accepts that we need to tackle that record high caseload. I think there'll be more news coming in the months ahead about our successes in that regard. But ultimately, judicial recruitment works quite slowly. We're in the process of recruiting new salaried judges and new fee-paid judges. But we also have, and some of you will have perhaps seen this in the legal commentary, a power now to inwardly deploy into the Employment Tribunal judges from other jurisdictions. And I did see reference in some of the online commentary to judges being, I think the phrase was, parachuted into the employment tribunals to hear ET cases. And that prompted some quite justifiable concerns from users that we would be diluting our traditional and much valued specialism. And what I can reassure you about is that any inward deployment is subject to an important series of safeguards and consents from both Shona and I, which effectively means we are not going to accept on inward deployment any judge to decide employment tribunal cases unless we are satisfied that they have employment law expertise. But there are quite a lot of judges in the system who work in other jurisdictions who have employment law expertise and might be in a position to respond to a call to arms, so to speak, if we ran an expressions of interest exercise to increase our judicial firepower. So we continue to battle away to get more resources, and I hope we will be successful. But of course, we compete with a number of other important public sector and public services for those resources, and we'll just continue to do what we can. So the message, I would hope, is one of cautious optimism. Again, thanking all of you for the forbearance you've shown while we have got into a recovery position, and also to report to you the signs of recovery that I have that suggest that we are now fully geared up to run remote hearings in the numbers that are needed to tackle our backlog. I know you'll have lots of questions, so I'll stop there and open it up through Daniel, and I hope I can assist with the other questions that you'll have. So thanks.
Judge Clarke, thank you. Tara Warner and Penny Douglas will be coming to you in just a moment, but first we have a question from Sarah McCloskey. Sarah, please go ahead.
Thanks, Daniel, and thank you, Judge Barry Clarke. That was really informative, thank you. I appreciate that you've kind of covered my question to some extent, but my question was, at the National User Group meeting in June, you raised concerns that the rising backlog would pose huge challenges to the ability of the ET to deliver justice within a reasonable time. So my question is, where does the ET system stand today on this challenge, and what further support or action do you think could help?
Yeah, so to put this in context, in the user group minutes, I referred to publicly available data as to the backlog that the Employment Tribunal faces. And if I can explain it in these terms, and it's a circuitous route to answering your question, Sarah, but I promise you I'll get there, is we have what we call single cases and we have multiple cases. And single cases, a single case could be one claim for unpaid wages, or it could be a case alleging unfair dismissal, discrimination, whistleblowing that's listed for a multi-day hearing. That's also a single. And back in March 2017, the user group minutes recorded me saying that we had 10,000 single cases in the system awaiting determination. And that, of course, was a few months prior to the Supreme Court decision in the Unison case. By March 2018, that figure was at 19,000. A year later, it was at 27,000. And it was beginning to level off as a consequence of us recruiting 58 new salaried employment judges throughout 2019. So that by early March 2020, it was around the 30,000 mark. That's still high, but it felt with our new judges on board that we had a strategy for tackling it. What COVID has done is resulted not only in a period where we couldn't hear those cases, but a period of time when our receipts have gone up. Because if people aren't paid or they lose their job through expressing concerns about health and safety at work, that's going to come to our doors. And as is well known, the Employment Tribunal's caseload is counter-cyclical to the economy. So when the economy struggles, our workload goes up. So pre-COVID, it was at just over 30,000. And the last published figure that was made available to the public put the figure at about 41,500 cases. And you can start to extrapolate those figures to produce an average waiting time across the country. Now, the comment I made at the user group meeting was on the assumption that we couldn't manage to gear the jurisdiction up to conducting remote hearings in volume. And I'll confess to a degree of cognitive dissonance on my own part at that stage, because I too was wary about what a video hearing would look like, how successful it would be. But having seen, running them myself as well as hearing feedback from the users, having seen that there is a broad consensus that it works pretty well. I mean, I won't say it's as good as an in-person hearing, but it is a good enough method to help us keep justice on the move. That has enabled us to reduce the rate of increase of the caseload. It's still going up and it will continue to go up, but the challenge to keep it down requires a huge investment of resources. Now, as a judge, I'm not a civil servant, I'm not an elected politician. All I can do is say, I recognise that there is a need for more resources and we are asking for them, but equally recognising that I can't just turn to HMCTS with my palms open and expect things to be handed into them, because all parts of the justice system are struggling with the resources that we need to keep justice moving. I would like to, I think it's going to we're still going to struggle for a while, because it takes time to get new judges on board and embedded and working on cases. But I think CVP has to be seen not just as a response to COVID and to get us through 2020/21, but as a response to the backlog. And we have to continue using it in order to tackle that backlog. So to put it in a slightly different context, CVP effectively triples the size of our estate. And whereas before we only had X number of rooms in Croydon to hear a case, now we have X plus all the CVP rooms. Those CVP rooms, some of them are used in hybrid hearings, so they don't really provide extra. But where we can have a wholly remote hearing, and if the parties are happy to have a wholly remote hearing, that can be done in an entirely new way. So the challenge is still there. But my absolute priority has to be to ensure that waiting times are brought down. And the waiting time is not uniform across the country. The waiting time is longest in London and the South East. And that's where the resources need to be deployed most urgently.
Thank you. Judge, if I'd known you were going to mention Croydon, I would have arranged for a Zoom poll saying, would people prefer a hearing by CVP or having to go to Croydon? But sadly, there's not time to set that up. Tara Warner is next. Tara, good afternoon. What's your question?
A question that I guess is on a lot of people's lips is, I'm just keen to understand if there is going to be a fee system reintroduced at any point. I think to your point, there is a huge increase in claims, and I do believe, and I'm certainly dealing with one or two at the moment, I believe some of them are there to be vexatious, and if there was an obstacle in the way, that perhaps some of them would be prevented.
Well, it's always been the case that the Employment Tribunal has received weak claims from some. It's also been true that the Employment Tribunal has received weak responses. And my experience over 15 years as a judge in the Employment Tribunal system is that there are equal numbers in both categories. And the question about whether one uses fees as a way of, again, forgive me for the slight management speak, suppressing demand is ultimately a question that politicians have to answer. As a leadership judge, one of my totemic principles has to be to preserve and safeguard access to justice. And I am not aware of any proposals at the moment that government are bringing forward to reintroduce fees. But if there were to be such proposals, then obviously I would want to be sure that they had minimal impact on access to justice. So I believe there was a parliamentary question asked about this over the summer, and I don't have the answer to that parliamentary question in front of me. I imagine it's quite easy to look up on Hansard, but the response to that question was along the lines of, there are no plans to reintroduce employment tribunal fees. And I'm sure if there were to be, there'd be a public consultation exercise and you'd hear all about it.
Thank you very much.
Thank you. Penny Douglas. Penny, good afternoon.
Good afternoon, Daniel. Good afternoon, Judge Clarke. Right. One question I've got. How can we address what is seemingly unfair, the differences between a claimant attending a hearing remotely when they've only got a smartphone and potentially very poor internet connectivity, and respondents who have access to high tech?
I mean, I would say I have done hearings in the Employment Tribunal, in the County Court and in the EAT using a variety of wholly remote, partly remote and in-person settings. And I have not found there to be personally a correlation between claimants not having access to the tech and respondents who do have access to the tech. Where you do tend to see differences is in the strength of cellular coverage around the country. So if people are calling in from a more rural location, that is tricky. I know a number of people, if they are represented, will go to the offices of their solicitors in order to have a decent Wi-Fi network and give evidence that way. And I have found a number of people whose access to justice is in fact enhanced through being able to use a smartphone. A case, for example, where the claimant was still at work, but was able, it was just a short hearing, to give evidence from their van on their smartphone on a claim that wasn't, where the respondent had not put in a defence. They didn't need to travel to an employment tribunal hearing centre anymore. They were able to deal with the matter just using, joining in over their smartphone to the CVP room. Similarly, I've done a case where an individual would otherwise have had to fly back to the UK in order to argue their case, but called in from overseas in order to do it. The great advantage of CVP, and I recognise it's not a panacea or an answer to every question, but it's that it's based on a web browser system, which means anybody with a smartphone can use it, and so long as the cellular coverage is equally strong, will have the same type of connection as anyone else. They don't need to download any software. They don't need to buy a particular device in order to access it. And that's why I think it, and indeed, I should just briefly say, I often hear people say, well, why don't you just use Teams? But CVP is compatible with Teams. It's compatible with Skype. You can call it from within those applications. So I do think it works reasonably well. But ultimately, if an individual says, I don't have the kit, the IT software or hardware to enable me to participate in this remote hearing, my presidential guidance says to judges and members, although it's not binding on them, that that is a relevant factor for them to consider over whether a case should be done in a remote setting. And it's perfectly open to the judge when listing the case to decide that somebody who doesn't have access to the equipment that they need can come into the employment tribunal whilst the other party dial in remotely. And you can have all sorts of permutations and combinations of who's present in the room and who isn't. So although it's not a perfect situation we face, what we want to do is be as flexible as possible, recognizing that one size does not fit all, and try and create a hearing environment that best serves the needs of that particular case. And if an individual does not have the means of joining a remote hearing, they need to tell us so that we can adapt the way delivery of justice looks accordingly.
Penny, thank you. Judge, just picking up on that, do you know if there have yet been any challenges in the Employment Appeal Tribunal to any case management decisions by judges designating particular cases as either CVP or hybrid or in person?
I'm not aware of any that have been brought by way of appeal. What I can say is that the President's Office and indeed the regional employment judges do receive quite a lot of correspondence from litigants, both sides, who are aggrieved at the choice of the vehicle through which the hearing will be delivered. But ultimately, it's a case management decision. And what I've noticed, if it doesn't, it's answering a different question, Daniel, but I think I'll just make the point briefly. What I've noticed is people's views of the value of remote participation have changed. So whereas in April and May, barristers and some users, unrepresented users, were saying to us, this needs to be in person in order for the hearing to be effective. And we were receiving correspondence that was complaining if it was to be held remotely. Now we get the correspondence when people say, why are you requiring us to come to a hearing when public transport isn't as safe as we would wish it to be? Why can't we do it remotely? And so actually what I've noticed is a change in the approach of people who are now learning to live with remote participation and in many circumstances prefer it. But no, the answer to your question is not aware of any appeals.
Thank you. Mark Mullenbeck, we're coming to you now. After Mark, we have Robert Davidson, David Leach and Roshan Khan. If you have a question to ask Judge Barry Clarke, please pop it in the Q&A box. If you look under the picture of me, you'll see a button that says Q&A. And that's where to type your question. We'll then take people in turn. But as I said, it is Mark Mullenbeck. Mark, good afternoon.
Hello. I think I had two questions, so I'm not sure which one you've picked up on, but I think the one was, I think I can understand why fees were abolished, but I think it's within the Employment Tribunal's power to issue fees towards paying for costs. Now, I do realize that I think employers' fees for solicitors will be quite high, but can they do it on a sliding scale? So, if someone is unemployed, could they pay some contribution? I do feel, because we get a lot of cases where, it does feel that they are vexatious. So, and it is a lot of time, resource, and money for an employer. So, are the judges more willing to be open to
well, what I think your question does, Mark, is conflate the question of fees with the question of costs. So fees are what the state charges a user in order to have the ability to participate in the justice system. Fees operate in civil litigation, as many people will know, and they did operate for a while in the Employment Tribunal system, and that was the subject of litigation. That's a different question to whether there ought to be a costs jurisdiction or a different costs jurisdiction in the Employment Tribunal system. And the long tradition of the Employment Tribunals has been that we are a no-cost jurisdiction. And there are powers within the Employment Tribunal rules of procedure to award costs, but there is case law binding upon judges and members as to the principles they should apply as to whether it's appropriate to order costs. So there is already a discretion there to award costs, but I recognise people will have different views depending on who they mainly represent as to whether or not that jurisdiction ought to be that the cost jurisdiction ought to be different or exercised more frequently. But at the moment, it is the way it is. And all I can say, if anybody feels that their opponent has acted unreasonably in bringing or continuing with the cases, then the rules provide them with the basis to apply for costs, and the Employment Tribunal will apply the law appropriately in exercising its discretion as to whether or not to grant them.
Mark, in fact, it was your other question that got all of the thumbs up and was the really popular one. So do you want to ask that one as well? It's quite short.
Sure. The other question was, with employment tribunals, I think our employer is very hesitant to represent cases on their own. And sort of my thoughts towards it is, does it sort of create a balancing act that if you have a solicitor versus someone who's litigant in person, does that create a balance? And is it worthwhile for employers to represent themselves? Is that a good idea? would there be the same weight given to employers who don't have solicitors as employees will be given? Because I do know judges generally help employees where they're not, solicitors, and try and help them up. So is it worthwhile for employers to try and represent themselves in tribunals to get costs down?
Just before Judge Clarke answers that, Mark, the question you actually put in the box, which got all the thumbs up, was how do members of the public join cloud video?
Oh, sorry. Okay. Apologies.
So I'll let Judge Clarke answer both that and your question about
Sure.
the extent to which judges should help litigants in person.
Okay, well, I'll deal with the first one quickly. And I appreciate you'll have all had experiences of employment tribunal litigation that will inform your views of how successful the system is. But I've been doing it a long time, both as in previous life as a practitioner, and now as a holder of judicial office, and as someone who sits in more than one jurisdiction. And I can tell you that my view is that good cases win and bad cases lose. And there are cases in the middle where the quality of representation can assist the tribunal in deciding which way the case should go. But ultimately, the quality of a person's representation ought not to make a difference to whether a good argument wins or not. However, if that were true, there'd be no job for solicitors or barristers to advise their clients as to what the outcome of a case is likely to be, or to ensure that the right points are emphasised to the tribunal as part of the skill of advocacy. But the notion, I would dispute the notion that judges help employees. What judges do is they try to create a level playing field, equality of arms, through the overriding objective to ensure that both sides are able to express their views and make sure they have been heard on the issues in dispute. And I can think of many cases as the counterpoint to your observation, where the claimant was represented and the respondent was not. And so it is not, I think there's a bit of a myth around it always being claimants before us who are the ones who are unrepresented. It is a much more nuanced picture than that. The second point was about open justice. Open justice, I think, has been a success story. There's a temptation when one looks at technology to think it's about trying to do the same, to replicate or act as a facsimile of what the in-person experience is like. But there are times when the technology enables us to do things differently and better that simply aren't possible in an in-person environment. Because you can dial in and observe at the CVP hearing, it means that perhaps solicitors who ordinarily wouldn't have been able to justify to a client attendance at a hearing that they may have instructed counsel for can now watch it or pop in to see the judgment being delivered over CVP. Members of the public can watch it hearing more readily than they could before. We had a case in the northwest of England some months ago in the early days of the pandemic when we first started using CVP that had over 70 public observers dialing in to watch it over the CVP platform. Now there are limits to this. I mean, the whole system can only incorporate a certain thousands at any one point in time. So we can't turn these into sort of stadium affairs. But at the end of the day, it's a lot more people are able to watch it than would have been the case when they had to come up and sit on the row at the back. So I am confident that we have safeguarded the important principle of open justice. And if anything, I think we have improved open justice.
Mark, thank you for those questions. We are coming in a moment to Roshan Khan and Paman Singh. But before that, first up, David Leach, who I think is ready. David, good afternoon.
Good afternoon, Daniel, and good afternoon, Judge Clarke. Just a quick question is, you've mentioned that CVP is not a one-time thing and it's here to stay, plus with the increase of electronic bundles. Is the tribunal minded to move to a standardised platform system for everyone to use to disclose bundles to the courts and to get them to judges, rather than the mismatch of what we have per tribunal at the moment?
I would like to think so, David, and we're piloting a process along those lines. The eagle-eyed among you might have spotted a footnote in my presidential guidance where I referred to a document upload centre being piloted, and that has been piloted in Wales, and we are intending to roll it out nationally. What that provides essentially is a cloud location to which parties can upload their electronic documents, or the one of the parties that is represented can do so. And then as a consequence of that, the judges and members can access it. That's so much easier than trying to email a scanned bundle, which can often be too big to get through the HMCTS firewall. And it's also better than sending in paper copies, which is what was happening in the early days of the pandemic, and asking HMCTS staff to scan and send them to people sitting remotely. The more we can use electronic bundles, recognizing their limitations and recognizing that not everyone has access to the software that does it, but the more we can use them, the more nimble we become in the conduct of remote hearings, because as cases settle the day before, we can move members around and reallocate bundles at the click of a mouse rather than requiring things to be sent in the post again. So the hope is to have this cloud-based system. It's coming. It's something we've been piloting, and I hope you don't have to wait too much longer. And can I just say on one other thing, I'm slightly nervous about the phrase "I have said CVP is here to stay," going without challenge. The extent to which we use video hearings in the future is the big question. Caps lock, underlined and in bold. It's the big question. And the reality is we have to continue observing how the experience of justice in that setting works. We have to do a proper survey of our users to see what's working for them. We have to remember that one size does not fit all. And when we've done a proper data capture exercise, then in consultation with our users, we can sit back and say, what's the long-term future of this? I do think for certain sorts of case, it will continue to be a really important tool in our toolkit for the delivery of justice. But I just want to make sure that the subtleties around its future use are understood.
Thank you.
Thank you. Roshan Khan.
So good afternoon, Judge Barry and Daniel. It's good to hear your talk. It's very, very informative.
And nice to see you again, Roshan.
Lovely to see you, Barry. It's really, really nice.
Roshan and I go back a long way.
Yes. My question is, having done both, conducted both the video hearings and also hearing in person during this challenging period, I have to say that it all seems to work very well, very convenient for both the clients and myself, and for all of the parties. So that system seems to be working. And even in-person hearing where we use two courtrooms to actually, one where all the advocates and the judges were and the witness who were being examined, and the other courtroom being used as a public gallery in effect for the witnesses to watch, see what is going on. So that all worked very well. And I hear you say the efforts are being made to make access to justice available, to claim form, make it as easy as possible for people. One has to look at the other end. What is the situation in receiving decisions after the hearing has been conducted? I know the tribunal, or I understand the tribunal rules say that it's as soon as reasonably practicable, this decision goes out. But my recent experience has been that I'm long awaiting decisions in excess of 3 months. So I just wonder whether that's a general thing across throughout the country, or it's just me in one particular case. Not a particularly long case, just a one-day hearing, and I just wonder what the situation is overall.
Okay, I think this issue probably stands apart from COVID and the response to the pandemic, because it's about the ability of judges to deliver their judgments within a reasonable time. And although the rules themselves do not provide a deadline for the delivery of the judgment, what I can say is that we train our judges as often as possible to extemporize, in other words, to deliver an oral judgment there and then on the day. But there are cases where judgment has to be reserved, and where it has to be reserved, we ask judges to get that judgment out within 28 days, and there is a backstop of 3 months. The longer that period goes on, the greater the risk that the perception of the parties is that the judge will have forgotten the evidence that they heard. And all I can say in those circumstances is if you've got an outstanding judgment that's past 3 months, it's completely fine to write into the tribunal office for the attention of the regional employment judge and ask for an update, because it may be that what's needed is for the regional employment judge to arrange for the judge to have a bit more time to write up that case so that it can get done. I think the frankly more honest response to me, Roshan, is to say, if you've been kept waiting more than 3 months, that's not acceptable, and I'm sorry about that. And you can write into the regional employment judge to raise a concern about that in the hope that it might expedite delivery of that judgment.
Thank you very much.
Paman Singh is next. Paman is actually somebody who I know quite well from Twitter, where he is one of the absolute stars of employment law on Twitter. If you're on Twitter and don't follow him, you should. So Paman, when we turn to you now, please do tell everyone your Twitter handle before you ask Judge Clarke your question.
It's a good question, Daniel. I believe it's at Paman Singh. It's a very imaginative, but thank you very much. Barry, hi, always a pleasure.
Hi, Paman.
Are you?
I also follow Paman on Twitter, and can say that he's explained through that mechanism aspects of the furloughing scheme that have enlightened me as well.
Thank you very much. Very kind of you, but just following in the footsteps. On to my question. I know that there are quite a lot of other people who are looking to ask some questions. It's more to do with sort of time limits in the Employment Tribunal right now, and whether or not there has been any guidance or any discussion formally or informally at an employment judge level in relation to relaxing time limits for submitting a claim or for a response being received. I've received perhaps a dozen or so default judgments now where we've had to write in. Unfortunately, I mean, they've been set aside, but unfortunately there's a drain on the precious sort of resources of the tribunal. So I wonder if there's anything that has been discussed at judge level.
Yeah, if you forgive me, Paman, I'm going to just look to one side on like all of us, you know, I've learned to have to use another screen at the same time. And the FAQ document that we published at the start of June has a section on time limits in response to the pandemic. Insofar as claim forms are concerned, which I know isn't the question you asked, but for those who might be concerned about claimants, for example, having access to legal advice at a time when law firms might be closed, FAQ 18 deals with that one. And then FAQ 19 talks about, the question is, given the problems caused by the pandemic, will the ET extend the 28-day deadline by which a response should be provided? And what that answer also gives guidance on is the fact that we're developing a service mechanism by which, although the rules require us to send the claim form by post to the address given to us by the claimant for the respondent, that we're perfectly willing in certain circumstances with national employers to send it to a centralized email address so that it's picked up straight away. We've done that with a whole host of national employers, retail supermarkets. We've also done it with government departments. I'm slightly hesitant at the start to advertise the fact we were doing that because it would excite a lot of interest in that as a way of dealing with it. But ultimately, Shona and I decided we needed to be transparent. So FAQ 19 talks about, sorry, FAQ 20 on that list talks about how you might write in and say, for the duration of the pandemic, if you receive a claim against us, could you please ensure it's sent to this dedicated inbox? That makes it more likely it'll be picked up, less likely then we'll be in a situation where you have to seek to overturn a Rule 21 judgment.
Pamman, thank you. Judge, a couple of things. It's nearly 4 o'clock. Could I persuade you to keep going till 4:15?
I'm happy to keep going, Daniel.
Thank you. A few questions came into me by email before we started this. I'm just going to ask you two of them. First of all, I'm just summarising it. Are there many ET1s stuck in the system that haven't yet been served on respondents?
No, not anymore. There were, though. We've managed to reduce the backlog. There was a stage at which we had a very sizable number of ET1s in affecting the 3 London regions, Central, East and South, that were yet to be served. There are always, the system does not work perfectly. And from time to time, even before the pandemic, there'd be an error made and somebody would uncover an ET1 that hadn't been served, and we would write and we would apologise and we'd get the case up and running again. This issue affected London more than any others during the pandemic because, of course, administrative staff had to use public transport to get into Victory House, Import Building, Montague Court and all the rest of it, and they couldn't get in order to do their jobs, and therefore those ET1s did sit there unserved for a while, but progress has been made in tackling those, and I'm pretty confident that the backlog of unserved claims has now been addressed. I hope that's the case.
Thank you. And another question I was sent by email, it's a little similar to Roshan Khan's question. If somebody sent in an application in the normal course of events for a case management order and it's not responded to, should litigants accept there's a backlog and just wait, or should they chase actively? Yeah,
I mean, this is such a dilemma, isn't it? I mean, I think they should just chase, I'm afraid. I am aware, and I receive correspondence of cases where people have written in and they've phoned, and the phone hasn't been picked up, or they've written in and they've chased and there hasn't been an answer. And I've intervened in some cases, not because I have any extra purchase, but just because it's been brought to my attention. I'm able to bring it to the regional employment judge's attention, and we can get something done top down rather than wait for something bottom up to be noticed in the inbox. I do think So the answer is I think people should just chase, and I know that's not going to be taken very well by administrative colleagues, but people will need to be. We need to reassure your clients that you're doing everything in your power to get that application dealt with. But if I can strike one note of cautious optimism for the future. I haven't mentioned our case management system because it's a bit of an Anaraki point. There aren't many people that know about ETHOS. ETHOS is an acronym, the Employment Tribunal Hearing Operating Software, and we've had it for years. It looks a little bit like an MS-DOS system for those that go back that long, and it needs to be modernized, and we're in the process of rolling out its replacement, which currently is known as ECM, which is Employment Case Management. And it looks at the moment a little bit like, for those of you who've seen it, the system that works in the Social Security Tribunal, in that you can, it tells you all of the cases that are in the system and you can gather and capture data quite quickly. What I want to achieve, and this will take some time, is a version of ECM that has public access. I want to be in a position whereby you as users and representatives can log on to the system, enter your case number and a password or whatever, and be told what the current status of your case is and your application. That seems to me in 2020 not to be an overly ambitious proposal, and that's what I'd like to get to. Once we get there, people don't have to worry about correspondence not being read or phones not being picked up, because people will just log on to see the answer to their question.
Thank you. I owe an apology to Rebecca McAleese, who was waiting patiently to ask a question, and it turns out I just asked the question she was planning to ask, so I've stolen her thunder. So instead of Rebecca, and apologies, Rebecca, we're going to come to Susan Thompson. Susan, good afternoon.
Good afternoon. I was just wondering what advice, reassurance you would give those of us who advise claimants as part of our practice in the South East and London region. We're not getting full merits hearings now listed till late 21, early 22 even. It's making settlement discussions very, very difficult, very one-sided in the employer's favour. So I was just wondering what advice, reassurance you would give on that front.
Yeah, okay. Susan's voice was quite quiet at my end, so I'll repeat the question for anyone who didn't pick it up, which was really about the challenges in London and the South East, where the waiting times are in fact longer. And I've been quite candid in accepting in public communications that in particular Watford and Croydon are where the delays are most lengthy, but I recognise that it does affect other offices as well. Well, I think I'd say the following. The first is that those are the venues where I'm hoping to assign as many as possible of the new salaried employment judges who will be coming on board in the next 6 months. Now, I know that's not a quick answer to your question, but when we recruited 58 salaried employment judges in 2019, we weren't able to get as many as we wanted to those particular areas. There are all sorts of reasons perhaps behind that. I don't know. But we were able to recruit to all other regions without difficulty, but those two regions came out frankly shortchanged in the allocation of judges. I was able to rectify that to a certain extent by giving them more fee-paid employment judges, but of course they don't sit quite as often. That's the first point. The second point is that the better equipped we get to run CVP hearings, the more chances there are of actually bringing forward a hearing date. So what you can do is if the parties are prepared to have a remote hearing, it may be possible to bring it forward and backfill the list at an earlier stage and get it heard quicker. That's going to be trickier for 5 or 10 day cases, but for cases of under a 5 day period, that might be something that's feasible. And I do know, for example, in the Southeast region, that the REJ is looking to find some of those late 2021 and early 22 cases and see if they can be brought forward. And the third point is that I'm not quite yet there, but I'm trying to develop what I'm calling a wholly remote cohort of judges and members that can effectively sit anywhere and therefore provide a way of filling the resources gap in London and the South East. So if, for example, you've got a fee-paid judge who's assigned to the North East region and they've just been cancelled because their 5 day case is settled, well, is there something we can give them in Croydon, or is there something we can give them in Watford? And it's not a well-known case outside of the ET judiciary, but there's a House of Lords decision called Lawal and Northern Spirit that says that fee-paid, the consequence of it effectively is that fee-paid judges can't practice in any other, in the region to which they are assigned. And if therefore they sit in another region, they have to agree to forego their practice in that region. And what I'm trying to do is set up a system whereby if the judge sits on a wholly remote basis on a sit-alone case, that they can do it in any region without it constraining their practice as a solicitor or barrister and the rest of their time in that region. And that, I hope, can deliver some extra resources to Watford and Croydon while we wait for the new judges to arrive. Ultimately, though, I absolutely accept that London and the South East, in particular Croydon and Watford, have the longer waiting periods. And I'm doing what I can to see if I can bring them back up to the swifter waiting times that one gets in Leeds or Birmingham or Cardiff, Bristol and all the other places where we have offices. So we're doing the best we can, Susan.
Just before we come to Saira, Judge, another question I've had by email is someone who says we've been unable to reach, I'm not going to name the region, but it's one of the London regions. We've been unable to reach the ET since September via telephone or email. Why can we not get through, and is there another approach we can take? I've actually had discussions with a particular regional employment judge concerned, and they are aware there is a problem with their email inbox being full and emails bouncing back to people. which causes litigants a lot of stress, but they don't know what to do about it.
Yeah, I think in leadership, personal honesty is really important. That's not acceptable. I absolutely accept that is not acceptable. But ultimately, I lead a group of judges, and I have to collaborate with HMCTS to ensure that there are enough administrative staff in place to deal with this task. And by way of example, it doesn't need to be the region you were discussing, but by way of example, during the pandemic in London Central Employment Tribunal, it was the judges who were monitoring and triaging the inbox. Now that is an administrative task, but they were doing it because there weren't enough staff available. And I praised HMCTS earlier, and I mean it because I'm praising the people that work for them that are doing the best they can and working long hours to get as much done as possible. But there are only so many of them. And if somebody is clerking a CVP hearing, they're not going to be in a position to answer the phone to someone else. And HMCTS understand this is a false economy, because if you're then answering the phone, that's something else is preventing you from doing. So the answer to this is, instead of having a system where judicial policy on the listing of cases is driven by the lack of administrative staff, is you need more administrative staff, and you need to come up with a better way of deploying them. And it may be that the answer to that is having some staff available in a national pool. For example, do you really need your CVP clerks to be based in the same office as the regional office that produces that case? Can they be based elsewhere and work remotely? The more we have ECM, this is the new case management system, which can be accessed remotely, and Ethos cannot be accessed remotely, then the more robust that becomes. And sorry, that is a point worth emphasizing. Ethos is such an antiquated system. It's based on a server physically housed in the building. So if the people can't get into the building, or there aren't enough staff in the building, you can't access that server remotely. Ethos's replacement, ECM, is a cloud-based system, which will mean staff can manage inboxes and so on remotely in a way that they couldn't do with Ethos, and that will make us more resilient. So I'd like to be able to say, here's a magic wand and it's going to make this work, but actually the strategy has to be to pitch for more resources that give us better resilience, but whilst accepting it's going to be still a few months while we struggle, and people should just carry on chasing. And I can only apologise for unacceptable delays in responding to telephone calls or emails.
Sayera Ramadan.
Hello, good afternoon to both of you. So my question really just follows on from a lot of the discussion that's just been had about delays and so forth, but it's in particular reference to Judge Clarke's advice previously that where there are long delays with receiving a judgment in particular, then an email to the regional employment judge might be something that prompts action. And I wondered if the same advice would also apply in respect of applications. And by way of example, we have a hearing that's coming up in April next year, and it concerns 4 different tribunal claims. A 5th one has been added, and we applied back in August, the middle of August, for an urgent telephone preliminary hearing to discuss that. As things stand in November, unfortunately, we still haven't had a response to that application despite chasing. Is this the point at which perhaps we escalate and write to the regional employment judge?
Short answer, Sayera, is yes. The regional employment judges, in a sense, won't thank me for increasing the correspondence that will pass across their desk. But if you're not getting a response from HMCTS, I do suggest that's the next port of call.
Thank you.
Thank you very much, Sayera. And we have time for one more question from Carol Haynes. Carol, I don't know if you have a working camera, but it's not switched on at the moment.
Hello?
Hello, Carol.
Can you hear me? Can you hear me? Sorry. Thank you very much today to both of you. But I've got one question. I had a hearing today, and I was asked by the employment judge about, is there a practice to limit the number of page numbers for witness statements in the trial bundle, which we don't do at London South. But I'm just wanting to know whether that's going to become a practice for us all across all of the tribunals to now start having limits on paperwork, essentially.
I think my response to this question would first of all be to accept that in most cases bundles are bigger than they need to be. My long-held view is that the approach to disclosure involved one side sending the other side all of their documents, the other side sending back all of their documents, and then them all getting combined into one bundle without really much thought being given or much filter exercised as to what the tribunal actually needs to see. And therefore a page limit on bundles can act as an appropriate discipline. And I would be keen to ensure that employment tribunal judges had the discretion to say, this is what we think is appropriate in this case. There have been cases where I have said, generally, I think a page number limit of X should operate. Should I make that a national practice? I'm more skeptical about that. I would rather lead the REJs in a way that empowers them to run their regions in the way they see fit. So if, for example, their local user community has responded to this being done on a cross-region basis, then I wouldn't want to stop them doing that, nor would I want to force it on another region that's not found it a helpful way of proceeding. But ultimately, it still will be an individual case management decision for that judge. And the advice I would give to those listening is, if you want to minimize the risks of an adverse page number limit, which you think is unduly constraining, then you need to exercise real thought as to what goes into the bundle that the judge actually needs to see. Do they need to see the entirety of the employee handbook if only the page that's relevant to the case is one or two paragraphs long? So it's not my intention to have a national standard on the number of page limit, a number of pages that should go in a bundle, the number of words in a witness statement, but it is part of the armory available to judges as to how they manage a case, and one size does not always fit all.
Thank you very much. Just one final quick question that's been asked through the chat box, which is, how do people find the contact details for their regional judge?
Well, they write to the office and they ask for it to be shown to the regional employment judge. I'm disinclined to release to the public the personal email addresses of all the regional employment judges for reasons I'm sure you'd all appreciate. But certainly if the email is marked for the attention of the regional employment judge, it ought to be drawn to the attention of the regional employment judge.
In fact, just while you were answering that question, Judge, I Googled regional employment judge on Google, and it came up new regional employment judge Daniel Barnett, because Google has picked up a bulletin I sent out about recent appointments to regional employment judges. But I did get
congratulations on your
bit of a fright for a moment. Thank you. Judge Clarke, thank you so much for joining us. The recording of this session is going to be made available in about 2 days' time. I will tweet the link for the recording and also send out an email update bulletin with a link to the recording. Judge Clarke, thank you so much for your time this afternoon. It's been a brilliant session. Thank you very much.
My pleasure. And once again, my thanks to all of those watching for their forbearance of us and the efforts they've made to adapt to the new world we live in.